see you and have some fun speaking with someone who's really a special person in our eDiscovery industry, and actually broader than that. She's an evangelical leader, if you will, in terms of taking eDiscovery processes and procedures and what we've learned in the past 15 or 20 years from eDiscovery and enlarging that and saying, what can we do with these things that we've learned to do modestly well in terms of legal departments in general? So I've got my great friend, Amy Sellars, with me today, and we're going to chat for about 15, 20, 25 minutes about a topic that I find really fascinating, and that's legal operations. I find it really fascinating because don't know much about it, and we're going to learn about it right together talking to Amy. So Amy, for those of you that out there that don't know a lot about you, which would surprise me, but for those that don't know a lot about you in the industry, tell us a little bit about your background and how you kind of came into this field.
Completely by back roads, I came into this field. I started life in not-for-profit arts. I was a big theater person. I love narrative. I love story. I went from there to teaching because I had kids, which was not conducive to doing theater at night. And I love teaching too. I taught theater. I taught English. It was terrific. But I, at some point, began to lose a little faith in the U.S. public school system. And I thought, I'm going to go to law school and I'm going to fix this. So I went to law school and I took a pretrial litigation class, and I never thought about education in America again. Because to me, this whole notion of putting together a story and sharing that story and trying to find the right outcome from different perspectives was so fascinating. And so I was hooked on litigation and frankly on data. I really began to appreciate how all of these pieces of a story add up in little increments.
Wow, really, that sounds like what I did so many years as a litigator, putting together stories and trying to be persuasive. Of course, one of the struggles we had a number of years ago was a dearth of information. We got information in a couple of sources. One was basically written paper documents that were typically sanitized and didn't have a lot of information on that was especially valuable. And human brains, which are terrible data retention sources because it's layered with bias and forgetfulness and everything. How did you get in the eDiscovery world? How did that really begin to percolate for you?
It percolated in the first big litigation case that I worked as a young associate, where we did not have a dearth of information. We had the exact opposite. Way too much information. Retention policies at the client were non-existent, so everything had been saved forever. And this was a dispute that really went back over many, many years of life of contract to formation of contract, course of business over all that time. And that could be just about any email that anybody sent talking about anything related to the business. So I had a small background in databases from having worked for an ed tech startup, and I was the only person in my firm who had any idea how this would work with the metadata. And so I got to really cut my teeth on a big data set in an early, processing and review platform. And I thought it was just about the most fun a person could have.
Yeah, that's so fascinating because really, I think a lot of this has come about because of, this characteristic of electronically stored information, that it's voluminous beyond imagination. And that's kind of led us to having to do things, I think, in ways that are more organized because, I could remember a couple hundred documents in the old days, but as soon as eDiscovery came around, I can't remember 200,000 or 2 million. It's impossible. So we have to have procedures and operations. It kind of reminds me of what I was teaching to my eDiscovery class this week, talking about processes and procedures dealing with essentially the preservation trigger and litigation holds, how we put that together, the documents that you need to get, plus the documents you need to create and need to use. So did that kind of play into what you're doing as well? And how are corporations beginning to internalize that to make sure their attorneys aren't out there flying by the seat of their pants, to use a metaphor that we don't like anymore.
I'm not sure that they're not still alive. If I look up, I may see lawyers going by in pants. But I think the first thing I'll say is that I think what George Socha did with the EDRM was somewhat transformational. Sometimes somebody shows you a very simple way of analyzing a problem, and it is actually transformational. So that notion of this became more complex over time, and quite quickly after a certain point in time, right? We ramped up, and then all of a sudden, boom, there's an information explosion. So George laid over that a way for people to think about an approach to the problem that helped organize multiple stakeholders, because that was one of the big differences too. It's not just more information. You have all these people who are stakeholders in a large discovery matter, and it's hard to coordinate. So the EDRM starts to provide that structure. Then you get legal project management coming into the fore in a way that it had never before. This idea that you could take project management principles and put them into some of the processes that George identified and helped define so clearly. So for me, that kind of, we are going to take a methodical approach. We will divide this into steps that are manageable, that people can understand, and we can make sure that we are documenting across this path. Because before that, you just had kind of, people were doing things, but they weren't doing them within the sense of a skeleton or a structure. That high-level process map really changed the way people thought about discovery and the way that they do discovery, and it made it far more professional. And then as we began to overlay analytics, we really got to some much higher level management of a complex task.
Yeah. Do you think organizations ought to have a standard eDiscovery binder, for lack of a better expression? Others, what I mean by a binder, and I kind of stole this idea from our good friend Mike Quartararo. If you look at Mike's book, eDiscovery Project Management, at the end of each chapter, he basically has the highlights of the chapter, which are great, but then he has the documentation, the issue, and the documentation that follows that particular issue. And I work closely with my students with that. And I say to them, look, you've got to build an eDiscovery binder that documents every step along the way when you're moving through the EDRM model and other things too, because as attorneys, we're preparing for conferences and Rule 26F conferences and depositions. But you got to have your eDiscovery binder so you know you're prepared, because you can't remember everything. And you have to have your checklist. And second of all, you want to have that later in the day in case somebody challenges what you've done. You can defend yourself and that your processes were legitimate. Yes. Are you see lawyers and companies moving in that direction?
I am. And I think it's critically important for outside counsel to feel more comfortable with the work that they're doing with in-house counsel, to know that the corporation itself has information about its own information that it can share in a methodical way, and that it has some idea of how these things will happen internally, so that outside counsel knows how long it takes to collect data, or whether they have to get a vendor to collect certain types of data, or whether data is living outside of the country in which they're litigating. So companies really have an obligation to their shareholders, to themselves, to write that playbook in a way where their outside counsel have a clear map for working with that company, and every company is different.
One of the topics that I see popping up in the literature a lot has to do with the new search or information retrieval technologies that are out there. And, I was wondering how you're looking at that in terms of figuring out which are the right ones for the right case, and kind of having a learning curve within the organization so that we don't make the same mistake in case 10 that we made in case number 2. And also educating the attorneys that you're working with about that, because frankly, too many attorneys, I think, even working in firms, operate as solo practitioners almost, in terms of, this is my case, I'm going to do it the way I've always done it, and I like keywords, or I like clustering, or I like concept, or I like AI, whatever. But it seems to me that you've got to have a systematic approach where you're looking at the needs of the case, figuring out what is the best technology, and frankly, what's most cost effective.
Oh, and so when the moment you say cost effective, right, you get right into the operations sphere, because that is it at the end of the day. You need a result that is cost effective and defensible. And so, from an operations perspective, there's all kinds of things you can do. But as you're looking across these options, how are you going to balance perfection, not our standard, right, and cost, and where those two will lie? And I think that that is one of the places where you really pull out this idea that a process, right, a consistent process, or at least a high-level roadmap, can be applied across all kinds of legal functions so that you can evaluate what is defensible and what is cost effective. So where do we find that happy medium in all of the other areas, like contract management, like electronic billing, right? All of these other fields that we have where these legal departments are growing and they're becoming more complex, and the functions that we have to support are more complex. And you go back and you look at where the eDiscovery professionals sort of paved the way for that to happen. What is contract management? It's collecting documents. It's assessing those documents. It's figuring out what technology is going to give you the information back about that body of documents that really run the business. So take your eDiscovery playbook and write it for contracts, and get your contract folks to think about themselves not as an individual making a document, but as a person who participates in a process where everything that they do affects everything else.
It kind of reminds me of the movie Moneyball in terms of doing analytics for baseball and figuring out what's important. Funny scenes with the Google boy and everything else. But what's happened, I think, as a result of what Billy Beane and others did with it, with the athletics, it's shown in a dramatic film in Moneyball, is I think other sports started looking at what kind of analytics can we use in basketball, what kind of analytics can we use in football, and frankly golf too, whatever the sport is. And I think you're talking about something similar. We've got a playbook we've developed in electronic discovery, and elements of that playbook are going to be applicable to other aspects of the business operation. If I'm not correct, is that what you're thinking?
Absolutely. And I love Moneyball because it's a lesson. It's a great movie. It's a fun movie, right? But this idea that you have to take the data and you have to think about it from a fresh perspective. You can't think about one player at a time or one piece of data at a time. You have to think about all of that data in the aggregate, right? Is exactly what we're talking about in almost all aspects of legal. And I have these contract folks, right, who are just starting to hear about contract AI, and of course the eDiscovery professionals are shaking their heads, going, "We've been telling you about this. This has been coming for a while." But again, so we'll go through the same learning curve and the same growing pains, but the people who've been in discovery are going to help that move faster. And I like that, right? We're going to move those other areas of legal into this age of data and discovery and analytics and technology faster than I'm an oldest child, so I like to think, I paved the way for my younger sister to not have quite as much parental intervention.
Excellent. What you say is true, though, because even in law schools, I'm finding more students that are really not litigation directed are coming into the discovery class because they want to see and understand and experience the skills that I'm teaching there and the software that's available, because there's I think a fundamental intuition that it can be used appropriately in other contexts. But let me ask you this question as we kind of come to the end of this wonderful chat we're having. We got a lot of attorneys in the audience here at the eDiscovery Conference, a lot of in-house counsel, a lot of attorneys that are retained counsel. And, attorneys, we want to make money. We want to send our kids to college and all that. So we have to work with our clients. When you develop an internal playbook, such as you're talking about, is that received well by attorneys? Does it create friction, or does it really create a platform that allows for better collaboration?
I found it to be the latter. I found that it's a huge relief when somebody says, do you have a standard protocol? Do you have a standard clause for this kind of contract? Do you have a standard way of billing? People really can do well, especially in the law, with rules, right? The guidelines are very helpful, and you don't have to reinvent the wheel every time you start something with a client. Knowing what the client prefers, getting that sort of settled so that you can work in that way, I think is terrific. And I really appreciate outside counsel who look at what we have and say, I once did something this way. I thought it was really impactful. You should consider this. That's amazing, right? That helps me mature my processes across all kinds of things. So I look for that, and I really appreciate that. So it's not here's the rules of the road, but it is hey, let's start here and work from here so that we're on the same page.
Yeah, it reminds me of when I'm working with someone writing a paper or brief or whatever. We don't accomplish a lot just sitting around talking. I want a draft to work on. And then once I got a draft and someone's laid out what they think they want to do and what the document is going to look like, I can edit it, I can add to it. All of a sudden, my creative juices get going. And then we have a real collaborative effort in terms of getting the best possible result for the client. That's something you're experiencing. It's great.
Yes, it is. And again, those are, I appreciate the counsel who take the guidelines and sort of work within them, but I'm even more grateful for the counsel who come back and say, I know you're a business and I know you're working on this. What if you tried? Those are terrific conversations.
All right. Well, let's wrap it up. This has been a great conversation we've had. I really appreciate you spending time with us. And it's wonderful to have you as a participant in the conference and doing this session with us. Amy Sellars, thank you so much. And this is Bill Hamilton at the University of Florida, Levin College of Law.